Um, my name is Richard Jolly, and I serve as the research fellow for the Civil Jury Project at NYU School of Law. Unfortunately, our executive director, Steve Sussman, couldn't be with us today. While he serves as the executive director for the program, he's still practicing law full-time and is, in fact, at a jury trial in Delaware. But I am here, and I think we can keep the show going on. First, I would like to thank our sponsoring organizations whose names appear on the screen. Additionally, the law firms that are hosting the event, and everyone here who is ready to appreciate and thank the jurors who are also here today. As you might know, this week is Jury Appreciation Week in Texas. That was signed into law in 2015, so this is only the second Jury Appreciation Week yet, and the Civil Jury Project is happy to be a part of that. The idea is basically to recognize the contributions that jurors make to the American judicial system. They take time out of their personal and professional lives to ensure that the continued legitimacy of our system is realized. And we want to make sure that they are acknowledged for that. What's great about Jury Appreciation Week is it actually matches very closely with the Civil Jury Project's objectives and mission. We are a academic institution, but also one that seeks to raise awareness of the decline in juries. While in the 1960s, the percentage of jury trials, the percentage of cases that were disposed of by jury trials was around 5%. That number today is around 0.6%. That is a dramatic decline and one that has very real consequences. And we've been trying to raise awareness of that decline both through our social media outreach programs and through our empirical research. We just launched a new website entitled We the People, We the Jury, which aims to connect people who have served on juries with those who have not served. We've learned that those who do serve leave with a great respect for the institution, and those who actually don't serve continue to dread serving. That's an interesting disconnect there. And so what we'd like to do is to put people in touch with those who have served and those who haven't yet so that they can learn what a great experience it actually is. So we have a Facebook, a Twitter, Instagram, LinkedIn. I can't even keep track of all of them, but we've got them all and we're present, and we urge you to check those out. In addition, we've been engaging in empirical research. As I think we let you know last time, we conducted one of the largest surveys of practicing attorneys in the United States with the help of the American Society of Trial Consultants to learn about why they thought that jury trials were disappearing. The answers that they returned were mostly related to judges who they saw as too managerial and legislatures who they saw as too anti-litigation. Surprisingly, in our early studies of why judges think they're disappearing, they think that the practitioners are too risk-adverse, and that's a pretty interesting juxtaposition. In addition, we're also studying what the public thinks about the disappearing of jury trials. Our hunch is that they aren't aware that this is happening. They probably think that there is a litigation explosion. There's been a hugely successful movement in this country over the past 30 years to convince the public as such. And we'd like to know if that's what their experience is or what they think of the decline in jury trials. We're doing that also with the help of the American Society of Trial Consultants, who are administering a survey through their mock jury practices. In addition, we also are near publication with a project we've been working on with two professors at Baylor Law School. That study is an update of a study done from a couple of professors at NYU about 10 years ago. And essentially what we're doing is reviewing 8K contracts filed with the SEC. These are contracts that were filed by public companies, business-to-business contracts that are important enough to be considered material. And we're studying whether or not they include arbitration or jury waiver clauses. If we hear over and over again that jury trials are too expensive and that arbitration is a quicker, easier, more efficient answer, one might expect that these clauses in their contracts would appear with great frequency. The truth is they don't appear with the frequency one might expect. The numbers are more than 50% of these contracts do not contain those clauses, which is a fascinating result that we're continuing to analyze. In addition, I wanted to bring to your attention something that we find pretty exciting at the Civil Jury Project. Again, we mentioned this last time, but there's been a development. Now Justice Gorsuch, a lot of people don't realize, but he's a big proponent of civil litigation innovations and reform. And in fact, here we have a memorandum dated not less than a year ago that then Judge Gorsuch had written to a couple of judges proposing that civil litigation should proceed in the same way that criminal litigation does in terms of whether or not you have a jury without having to request one. That you would have to waive your right to a civil jury rather than have to request your right to a jury. And he says in this memo that a few reasons animate his proposal. The first one is that he thinks we should be encouraging jury trials. The democratic contributions into the judiciary is of value. Another reason is that simplicity is a virtue, he says, and that this new rule would produce greater certainty. And finally, he suggests that jury trial default honors the Seventh Amendment more fully. And whether or not this type of proposal is implemented or whether or not states choose to do so, it's still an interesting insight of someone who's the newest member on the court. So that's a little bit about what the Civil Jury Project has been doing. Today we are here, though, for the Jury Improvement Lunch. And we're going to invite our judges and jurors up on stage. But first, let me acknowledge some of the judges that we have here today with us. Is Judge, and if you could stand up when I call your name, Judge Dan Hind. Oh, no, I'm sorry. Judge Dan Hind actually has a trial right now, and hopefully he'll be making it back in time. That's right. Judge Landrum. Judge Rosenthal. Judge Ellison. Judge Sandel. There was a few that were going to be able to make it or not make it. Judge Palmer is... Are there any judges that I've missed? Well, before I invite the judges that are have their names up here, I also want to acknowledge our jurors. John Eugene. Diana Jimenez. Regina Living. Regina. Kristen Holloway. Rosa Maria Flores. And Howard Ledette III. If you guys can come up on stage now, we can get the panels going. So there's a few mics in front of you guys. If you could speak into the mic when you respond, we have a recording going on. So my first question is for the jurors who recently served. Did any of you guys serve on a federal rather than a state jury? Do you know? Did you serve on a civil or criminal case?
Civil.
You all served on civil cases. Fantastic. How long did the case last?
4 days.
4 days.
3 days.
3 days.
4.
2.5.
2.5.
3 days.
Okay, so all pretty quick trials. So I want to ask a little bit about when you first received your summons. Do you guys remember getting the summons in the mail? Were you excited? Were you nervous? Please.
Wish they wouldn't have gave it to somebody else.
You wish you could. Anyone else?
But yeah, I was rather excited, pretty much, because this is the previous time I got called. I lived in a different county, so I couldn't go. But this is technically my first time, and I was rather excited because I'm a big TV junkie, so I only see it on TV. So I don't know about anybody else, but I was rather excited, and I wasn't excited to get picked, but I was excited to go.
Had anybody else served on a jury before?
Yes.
So did that inform then perhaps your lack of excitement?
Well, they were different. It was criminal.
That one was a criminal case. Okay. When you did report to the courthouse, was it like anything you'd seen on television? Did your excitement persist?
No, it was different from, I guess, a quick flash on the television screen. But I mean, the in between details, like the judge and attorney actually walking through the questioning and what's going to happen, I didn't see that on TV, and that was comfortable. I do appreciate that, but it was very much different from what I see on the television screen.
For some of the people that weren't as excited to receive your jury summons, did you guys consider perhaps ways of trying to avoid serving? Some people, they'll still report, but they'll
I
try.
did.
Did you? Would you feel comfortable telling us maybe what you tried?
I do have some grandkids. I started to use them as an excuse. But then I say, well, this is my duty. Let me go ahead on and go in and hope I don't get picked. But I wind up being picked. I kind of just sit to the side and didn't say nothing. Hold my head to the side. Y'all don't pick me. But I heard my name. And so far, it was good, though. I really enjoyed it. A good experience for me. And I'll do it again if I have to.
I guess I want to ask the judges a question. I guess you guys probably see people maybe using other responsibilities to try to get out of serving. How do you address those situations? And what would you say to those jurors maybe who are planning on using various excuses?
It depends. I know that's always helpful to hear, but it really does depend. And I'd be interested in what some of the other judges think too. When I have someone who is a well-educated professional who comes before me and says, I'm essentially just too important to be away from my day job or my daily responsibilities to show up in a jury trial, I have to contain my fill in the blank word. It just drives me nuts. I mean, these doctors go on vacation. They arrange call all the time. Lawyers in the room, you're great people, but you're not indispensable on any given day, I promise you. And there's just teachers. There is a whole tribe called subs. City employees of high-level jobs, supervisory jobs. That drives me nuts. And the ones that break your heart are the ones who come in and say, my job depends whether I get paid, entirely depends on whether I show up. And I've been out of a job for X period. I finally have some work. If I get put on a jury now, I'm going to lose it. Or I have to drive umpty-ump miles. You want your juries to be a cross-section. You don't want just the rich professionals or the middle management. And yet the ones who you depend on for the diversity of views, for the richness of perspective and experience that the jury brings that nothing else can. And I'm a big fan of 12-person juries in civil cases, in part because of that diversity and richness that the larger number ensures. it's a really hard choice. Do you let this person go on a hardship basis? Or do you say, I'm sorry, we really need you here? That's a tough one. That can be tough. But the ones who come in and say, I'm a doctor and my plastic surgery practice really needs me, that's not tough.
I agree with Judge Rosenthal. In my introductory statement to a jury panel, I try to discourage people from claiming hardships. Make sure to tell them that the fact that they have a business appointment or some conflict like that just isn't going to be good enough. And that said, I'm very proud of the diversity and range of people that we get to appear for jury service. I try and kind of keep an eye on that, keep track of who shows up and who winds up on panels in the court. And I'm very pleased with the cross-section that we do get. But that said, we do get the people who will say things like, well, you know, I didn't get enough sleep last night and I'm not sure I can pay attention. And those kinds of excuses. Well, you know, we thank them very much and we make sure that they remain in the panel until the jury is picked. The part that drives me really crazy, though, is the people who think of their excuses after they've been impaneled on the jury, and they don't get a lot of sympathy.
Judge Hine, we were talking about those jurors who report to duty, but nevertheless will attempt various types of excuses. What's your experience with that, and how do you try to address it?
Well, when I talk to the jury before they go into the courtroom, I tell them, if you've got unavoidable scheduling conflicts, let us know. But I want to caution you, we may not be able to do anything about it. But I tell them an unavoidable scheduling conflict is non-elective surgery or medical treatment like chemotherapy. And let's face it, if someone says, I got chemotherapy tomorrow, I'm not going to keep them from their chemotherapy appointment. Or if they have non-refundable travel, if it's for business, I'm less sympathetic. But if it's, you know, for this time of year, it's graduation. I got to go up to New York to see my kid graduate from Cornell or something like that. NYU. NYU. Excuse me. I'm sorry. I just got back from taking a verdict, so I'm a little out of sorts. But yeah, we'll work around that. I'm less sympathetic to some of the folks who have the scheduling conflict because we make it super easy in the state courts to reschedule your jury service. You just go online to do it, and you can reschedule it to a week when you're not going to be on vacation or so forth. And so because there's that option out there, because there's the exemption, for instance, for people who are the primary caregiver of someone under 14, you can claim an exemption. You don't even have to show up. And so I sometimes get a little frustrated with the people who didn't do that. But we try, as with anything, we work through it. I usually handle the actual decision on exemptions with the lawyers after we've done strikes for cause to see if we're going to be having any issue with busting a panel or something. We usually don't. But we usually go through strikes for cause, and then I'll ask the lawyers, okay, juror number 13 has this quote unquote hardship. How do y'all feel about letting that person go? And most of the time, the lawyers are agreeable to letting them go. I very rarely am left with making the decision over someone's objection.
I wanted to ask the jurors, moving on with the impanelment portion of the trial, did you guys feel that the lawyers asked you questions to try to get to sort of maybe some of your biases or some of your beliefs about the case, whether or not you could try the case or judge the case impartially? What was your experience with that portion? Did you feel that the lawyers asked you questions that were fair? Did you have a difficulty answering them?
Yeah, they were fair.
They were fair. Did you? Sometimes people are worried that the questions are too personal or that they are maybe digging too deep. Was that your experience at all? Maybe.
Yeah, it was from my case, it was pretty much broad. It was very open-ended, but for the most part, they didn't poke around too much. Of course, they didn't have 2 days to ask questions to 50 people or whatever. But yeah, they kept it very open. Yeah.
Mine was more specific. They asked, did you have any prejudice against someone who was not born in the United States? Because the plaintiff was born in Egypt. So they want to bring that out right ahead of time. And we did have a couple of people who said, yes, I do.
Do you guys think maybe should they have poked around a little more? Do you think, perhaps not with that question, but maybe in one of your other cases, I don't know, Diana or Regina, perhaps in your cases, do you wish the lawyers, or do you think the lawyers should have maybe asked more pointed questions or more specific questions about the case?
Well, the lawyers that we dealt with, they were right on point. They brought it right in. Talk like a lawyer. Brought it right in and, told us just like it was. I think it was real nice because we understood exactly what they were talking about. They didn't beat around the bush. They just came straight with it. Do you like this? Do you have any objections about this? What do you think about this? And it was just straight to the point.
Christine, was that your experience as well?
Yes. On my case, it was a contractor, general contractor, suing another general contractor. So they asked people, does anyone have any problems with contracts? You can tell the people that are wanting to get out of it saying, yeah, I believe, you sign a contract, you go by the contract. But no, I felt they were very direct in their questions and so forth. But you can see very quickly who wants to weasel out, and and those people that generally want to be there, and if they're selected, they're selected.
One of the innovations that the Civil Jury Project has been promoting and studying is actually delivering opening statements to the entire veneer rather than just once the panel has been selected. So this would be, you would have learned more about the case, not just do you have a problem with contracts or is the case involve someone from out of the country, born out of the country, but perhaps more substantive. And the idea behind this is not to argue the case. That's something I'm sure the judges will tell us is both not allowed and not desirable. The idea is rather that for those people who actually will be dismissed from the veneer, go home, they might leave with a better experience. So something I mentioned earlier on in the panel was that those people who don't serve leave with a bad taste in their mouth. Their full day was ruined. They didn't even get to do anything. But for you guys had 2 or 3, maybe even 4 days where you had to serve, and yet you might have left with a better experience. It's counterintuitive, but the idea of contributing to a case gives you a greater feeling about it. Do you think that, I guess you guys were selected, but maybe if there was a case where you were dismissed, you served on multiple trials or you were called multiple times, that you would have liked to hear something about the case more at the beginning? So that's my question. Do you guys think that you would have liked to hear more about the case before the trial had started? Maybe having opening remarks from the attorneys. Maybe John?
No.
No.
No, because then it gives a lot more people excuses to make some false statements in order to get off jury duty. So just keep it the way it is, and that way you don't have people trying to come up with excuses.
Regina, do you agree with that?
Yes. We don't need to hear all that. We hear from the beginning when it's, picking us out and observing us, seeing, do I like that person? Do I like this person? We don't need to go all off to that long drawn thing because you're already sitting there. I'm ready to go home. Pick who you're going to pick and let me go, and then let the other people deal with it. That's the way I feel. I don't need to hear all that.
So you think the people that are already predisposed to not wanting to be there would use that as an opportunity to develop more?
Mm-hmm.
Is that what you guys think as well? Is that what you think?
Yeah, well, yeah. I definitely agree with John and Virginia. I'd rather not hear too many details because if I start to hear too much specifics about the case prior to, then whenever they dismiss everybody into the hall till they can pick, then people get in circles and start to be like, well, what about this and that and then we kind of stock the pond in our head.
Absolutely.
Yeah,
Yeah, that's
and-
actually the main reason why that's
Yeah.
one of the big pushbacks against why that isn't one of the practices. Perhaps the judges, would that be your same concern?
Definitely.
Judge Rosenthal? Yeah.
Yes, I mean, we already tell the denier not to get creative in coming up with reasons why they just can't be fair. And there is a risk in giving them enough material that it will increase their ability to come up with reasons that sound more plausible as a basis for getting out of the jury duty that they would otherwise face. Now, having said that, there's got to be a middle ground to maybe expanding what the judge, as opposed to the lawyers, might say are the competing allegations or the issues in the case, and not be as limited, as bare bones, as we sometimes are lured into being by interest in being brief, being fast, getting the panel out before lunch or whatever, and making sure that we don't get too far into the weeds that we wind up having to say either nothing or a whole bunch. And it's not easy to do, and I spend a lot of time sort of doing a summary based on what the lawyers give me in advance that I will read to the venire as the introduction to the voir dire. And I get the lawyers to tell me in advance if they think it should be changed or modified because it's either incorrect or inaccurate or slants too far in any one direction. So it's an effort in that direction. I'm still not satisfied that I, in any one case, hit that sweet spot between you're telling them way too much, you're over in TMI, or what's the opposite of TMI? NTMI?
Well, I also look at it from the case law point of view. Under Hyundai and Cortez, in the state law context, you start getting too many details about the facts, and then you take away your ability, basically, to strike jurors for cause. So I'm not sure, under the way the case law is set right now, that having opening statements before voir dire would really address some of the things that lawyers want to accomplish during jury selection. And so that's another concern. I think it's interesting, and I'm glad to have heard from our jurors on the panel that they don't think it's a good idea, because that's not a perspective I would have expected to have heard. And I'm glad I heard it, because I think that's it's refreshing to hear that.
I must say I was surprised as well. Moving on to the actual trial, when the case started and you were provided some instructions about what you were going to be doing, did you nevertheless feel that it would have been helpful to have maybe a little bit more information, more substantive instructions before the case had begun? For instance, in your contracts case, do you think it would have been helpful to know maybe just a little bit more about what the substance of the issue was? Not just that you're going to be there will be evidence presented to you, that you'll be expected to determine this, but perhaps maybe something a little bit more in depth, something that it wasn't given to you actually until the end of the trial, likely before you began deliberations. Do you think that would have been helpful to have that information up front, so that while you're listening to the case, while you're considering things, you actually kind of know what to be considering, what to pay more attention to? Would you have liked that? Do you think it was?
I think they were pretty upfront with information, initially. I know Diana was she was in my panel as well. But no, I felt like they were very forthcoming. I didn't feel like we needed to know any more, until we got started. So, no, I don't think there was anything lacking there.
Diana, would you agree?
I agree.
Can I?
Oh, please, yes.
Let me fine tune your question just
Please
a little
do.
bit.
Yes.
Would it have been helpful to have, for example, definitions of terms that you might be hearing during the trial, or maybe that kind of a thing? Would that have helped you as you listened to the evidence if you had had a list of definitions that were particular to your case, or maybe had something to do with the standard of proof or something like that?
I don't think so. I don't think in this particular case that we were lacking in anything or definitions or explanations. I think it was pretty understandable from the get-go.
John, would you agree? Was that your experience? Do you think definitions and more substantive instructions up front would have been helpful?
No, I don't think there needed to be any more instructions because I might have formed an opinion before I heard the evidence. So I'd like to keep it just as simple as possible. I mean, she went over exactly what it was going to be. It was a contract, and that was about it. And then we listened to the evidence. And if I thought if we got more information, I might have formed a judgment before hearing the testimony.
You think that might have been, you wouldn't have been able to maintain your impartiality until deliberations if you'd been given that type of instructions up front? You would have been more likely to come to a conclusion?
Yes.
Regina, would you agree?
I feel the same.
Can I ask a question of
Please.
our jurors?
Yeah.
It sounds like each of you had a case that was sort of right in the middle of the kind of experience that many of us have during our daily lives. A contract to build a house, maybe. And what kind of case was yours? A contract case as well, John?
It was a contract case.
And was it a kind of a contract and a kind of a transaction that you could have an intuitive sense about?
Yes.
And Diana, what was your case?
A contract. I was saying.
Oh, that's right. You became sisters in the panel. Got it. And how about you, Regina?
I was with John, so
Okay. That's right.
And Howard, what was your case, Howard?
It was pretty much a real estate contract and money
Okay.
money lost during contract.
So I guess my additional question would be, imagine if it had been a more complicated or technical case, like a copyright infringement or intellectual property or some kind of really complicated transaction with esoteric financing. Would you feel differently about whether you wanted more information up front?
Yes.
Yeah, yeah, definitely. If I may, yeah, the case that I had, certain glossary terms were defined, or they were asked by the overall panel before picking, and that had kind of made everybody kind of like pull back and like, hold it, what is that? But I'm happy that did happen. But yeah, I mean, pretty much we got the whole scope of a real estate deal gone bad, money lost, and then it wasn't too complicated. But yeah, I do agree with Judge Rosenthal that if it was more difficult or more able to chew, we would definitely need more because the average person doesn't know too much about.
the average judge.
There you go. So yeah, if it was more difficult, yeah, I mean, your regular daycare teacher doesn't know too much about what I guess a judge or attorney may know. Yeah.
Well, I guess I was going to ask this question. I'm worried, though, considering that some of the cases seem not to be too complex. Nevertheless, were there any instances where you wish during the trial, not necessarily afterwards, but during the trial, that you could have asked questions, that you could have asked for clarification, either on a glossary term or on a specific testimony, that you could have asked somebody when they said something, what they meant? Do you think was that something that you were able to do? Some judges allow that. Or do you wish it was something that you could have done at any point in the trial?
No, because in the trial we were on, the lawyers asked a lot of questions over and over and over and over again to the point that you wanted to say, will you stop?
Yeah, Howard, yes.
Yeah. Well, as my first time, like I guess I didn't know the proper etiquette to I guess if we could or not. I didn't. It's like I was a newbie all over again. But I didn't really know. But I wish that certain glossary terms, certain like contracts, like why was that signed then, or why was that needed then, to where it could have actually streamlined. Like yeah, we got the contracts in the docket of evidence, but we really didn't know like why everything was being presented at that time for the case. So stuff like that, I wish I could have asked, I guess, the general scope of the attorneys, why was that. But I mean, at the end of the day, it was 12 of us that really got the whole scope of, yes, something went wrong. So.
Dana or Regina, do you guys think maybe questions would have been helpful at all in the trial, being able to ask questions of either the attorneys or rather the witnesses' testimony? Not really. No. Judges, is this something you guys allow in your courtrooms? Do you think it's something that you've experimented with, you've had luck with, or you've had bad luck with? You're not really wanting to do it anymore. Judge Hind.
I have not done questions from the jury yet. A few years ago, we tried some project to try and use some experimental procedures in jury trials, and questions from the jury was one of the ones that we posed, and I never had any lawyers request to do it. And so if the lawyers aren't going to buy in on it, then on something like that, I'm probably not going to go out on a limb on it right now. But maybe in the future, I've heard jurors say it would be nice if they could ask a question and everything, and there are some procedures out there that some judges have tried. So it's something I'd consider, but I'd need the lawyers on both sides to agree to it.
And you haven't had that? You haven't had lawyer? No.
No, I agree with Judge Hind. I have broached the subject a time or two with lawyers, and I've not gotten an enthusiastic affirmative response.
Why do you guys think that the lawyers aren't enthusiastic? Or Judge Rosenthal,
Okay. I think that maybe the lawyers are afraid that the case will go off on a tangent because of that, or that the other side will get a clue about, maybe they've left something out of their questioning of the witness, and then that will, as Mr. Eugene said, that'll lead to another hour's worth of interrogation on a topic that may not be central to the case.
Judge Hine, you had something you wanted?
Yeah, I was just going to say, I think a little bit of it is most lawyers are type A personalities who like to be in control. That's my observation. And
very controversial.
You don't like handing questioning over to your opposing counsel, who at least in your view is trained in interrogating a witness. When you let go of even more control and start letting the jury ask those questions, I think that there's some angst and some stress that you may lose control of your case. That's just my pop psychology observation, but I think that may be part of it. And there's just the fact that it's something new and something different, and you're not familiar with it.
Judge Rosenthal?
I think all those theories are plausible. I wouldn't dismiss any of them. If there's any group that is more hidebound, slow to innovate, slow to change than judges, it would be lawyers. And I think that's part of it. There's a sort of an inertia and a cowardliness about being the first to go in a particular direction, especially when, as Judge Hine, I think quite correctly observes, it does relinquish some predictability and ability to control or shape the way in which things unfold, even if you can't predict or control the outcome ultimately. So all of that's right. I would never do it in a criminal case, which makes me stop and ask myself, well, why? In part because it's just a much more, there are more risks in deviating there because the stakes are in some ways higher, at least different, in ways that are hard to measure, but easy to conceive of. We all get that that we do need to be more cautious about innovating procedurally because procedure affects substantive rights, and we know that. But in a civil case, if both sides agree, why not? It's hard to think of a good reason as long as the judge is able, with the attorneys, to filter the questions that the entire jury panel asks. And I do worry that the jury will together come up with the questions and that they will, in that very exercise, start to solidify their thinking well before the evidence is concluded. And I worry about that because when you formulate questions, you really do sort of commit yourself to a certain way of looking at things. And that's not what we instruct jurors they need to be doing. They need to keep an open mind throughout. And I do worry about the kind of exercise that would lead to, and the result that exercise would lead to.
Since we're on the topic, sort of,
pop
of
psychology.
the attorneys in the room, I wonder if I could ask the jurors maybe if you could talk a little bit about the lawyers in the cases that you guys sat on. Were the lawyers? What were some of the things the lawyers did that you thought were really effective, maybe in helping you understand or convincing you of their case? What did you find was not effective, or that you found annoying or distracting? Mr. Eugene, you mentioned that they were very repetitive, for instance.
Just one.
Did you, out of curiosity, did you find for the annoying, repetitive lawyer's client, or the other client?
The other one.
Do you think then, and this is sort of what I want to go to as well, do you think that the lawyer's presentations and demeanors affected your perceptions of the case?
Well, it was the presentation. He didn't do it. The plaintiff's lawyer did not do as good of a job as the defendant's lawyer.
What did he do that wasn't as good?
Well, he kept on asking the same questions over and over again. I guess he thought that if he asked it about 5 or 6 times, we would be convinced. But it didn't work out that way. The other side, he was more precise. He seemed like he was more organized. And really, it came down to lawyer versus lawyer. Unfortunately, for the plaintiff, he picked the wrong guy.
Diana, what were some of your observations from the of the lawyers of the case you sat on?
I think there was one that was using the overhead projector, and it was kind of distracting. And then the other one had his laptop and had everything well organized, and that was very neat, and it was understanding.
So the use of technology in the courtroom
Yes.
can be both distracting or beneficial,
Yes.
depending on how. Regina, was that your perspective as well?
Yes, with me, it was like they was kind of bickering with each other. You know, they just constantly said the same thing over and over, over and over, over. I'm like, Lord have mercy. You know, one of them, he was looked like he was a little slow or something. I don't know what was wrong with him. But then the other one,
hold back.
the other lawyer, he, like you say, he had everything just lined out. But the other guy, he was like fumbling, making sure. And when we got down to the end, he did kind of do a little, even though he was doing all that fumbling, he brought about some good points. But before he come to the end, that was at the beginning, he was like, I'm like, oh my God, what is he doing? It like make you be tired. You're like, oh God, we gotta sit through this. But like I say, at the end, he kind of finally got it together to where he should have had it together at the beginning. Because it makes us as a juror, we sit there and you're in the chair, and oh Lord, here this man and he just constantly repeating. He repeat 50 times what this man said 2 times. I'm like, oh my God. But, as time, maybe he was getting something. I don't know what he was doing. But maybe he was getting himself together. It could have been might have been a little bit too much for him. Because it was like, you say you my lawyer, but I'm the one came over there and brought you the papers. I'm like, okay, what is this here? It kind of had you a little confused. But, yeah, they need to kind of tighten up a little bit.
Tighten up.
Yeah, just tighten up a little bit.
Christine, would you have the same idea that the lawyer should have tightened up a little bit, been less repetitive?
No, I mean, I think it became evident rather soon into the trial who had the stronger case and so forth. I think it was So no, I don't feel like.
Was it anything about the
I mean,
lawyers'
yes, it does-
presentations that made you feel that one side had the stronger case versus the other side?
No, but like Diana said, that the lawyer for the plaintiff would fumble a lot. The technology, the projector. Actually, the defendant's lawyer actually kind of assisted him to help him. No, I mean, I don't think, I think it was pretty evident, like I said, from early on who had the stronger case, and so I don't feel like there was anything that needed tightening or anything in that respect.
Howard, you mentioned that when you were first coming to the courthouse, you were interested in maybe something like television. Were the attorneys present anything like what you see on TV?
Not at all. Not at all. Yeah, I really need to stop watching television. As far as like presentation and demeanor, I mean, keep in mind I'm ignorant to everything. Being my first time as a juror, the attorney's presentation, one was rather suave and rather like streamlined, but still he kind of deviated every now and then to try to trick the plaintiff, who was on the witness stand, into actually, try to trick the defendant who was on the witness stand, to try to like fool her up and try to like get her to actually admit to herself, like, yeah, you actually did wrong. But I did notice that for quite a few questions. But I mean, I guess attributes. That guy, he was pretty much haven't been practicing law. I think he said 6-7 years. Now the other attorney the other two attorneys on the other hand, they're old timers. They've been doing this 30-40 years. Right from the get-go, I said in my head that those 60-year-old men, they're probably just going to stay on the straight path and just ask simple questions. and that was so easy to follow. But the other guy, I mean, like his suaveness and his kind of like the way he presented his argument, it was rather neat, yet it was almost like, what are you trying to distract us from? And that was noticeable, like 2 or 3 times. Well, at least I noticed it. I'm not sure anybody else did it. But I don't know, the mantra and deliberation, beyond any demeanor or any presentation antics or niceness or simplicity or not, the mantra and deliberation we all kept saying was, let's just follow the evidence and let's not go with the theatrics and the circus acts these attorneys trying to play. Let's just follow what's here. But yeah, it was nice.
You brought up deliberations, and that's kind of what I want to move to next. Would you guys have liked to have been able to discuss amongst yourselves before final deliberations the evidence and the trial that was going on? Now, it sounds like you guys have repeatedly said that you're not sure you would have been able to maintain impartiality. You might have reached a conclusion too soon. And in fact, many states don't allow this practice precisely for that reason. Arizona, though, has been allowing it for at least a decade or so. And empirical research on their experiments show that people don't reach conclusions before they go into final deliberations. It shows that people keep an open mind. In fact, that they remain more engaged in the trial, that they aren't prone towards distraction or to boredom or to just generally not paying attention. Considering that you guys have suggested maybe that you don't think you would have, that would not have been your experience. You think that you would have reached a decision sooner. What makes you think that? John, you said that you think you wouldn't have been able to wait until the end. You think that if maybe there was more information up front, or maybe in this instance, if you were able to deliberate earlier, maybe you would have reached a conclusion sooner and not waited until the end. Why do you think that?
Well, on your original question, I think that, no, we shouldn't discuss it before, because you'll have strong members on the jury who will influence the weak ones ahead of time. So I think we should keep the way it is right now. What the instructions are, do not discuss this until deliberation.
How long did your case last for, again?
Too long, 4 days.
Did you find that during those 4 days, maybe there were times when your attention lulled?
Yes, Yes, and in fact, they told us it was going to only last 3 days, which included deliberation. But since the lawyer kept on talking more and more and more, and judge can't stop them. I mean, there was no objection, so they just kept on going. And yeah, we did lose this. We just tuned them out after a while. You know, it's like watching something in a loop.
Do any of the other jurors think that maybe the proposal of being able to deliberate, for what it's worth, in Arizona, you have to have everyone in the room at the time. Everyone has to agree, all the jurors have to agree that they want to engage in this pre-final deliberations practice. Well, that doesn't necessarily silence more opinionated individuals. At least Arizona's had good luck with it. Does anyone else think that this is something that they would have liked maybe Howard?
Quick question: are you talking about before?
Yeah, I'm sorry, I might have been a
all the
little
evidence?
confused. It's not final deliberations, just throughout the trial. Maybe after the first day, you can, and you're waiting to get called back into the courtroom. You're all sitting there. You're told don't talk about anything related to the trial. You're making small talk. Maybe instead you could have talked about, actually, I wish I could have better understood the timing, for instance, as you mentioned earlier, about why a contract was this way or that way. Do you think that would have been helpful? Do you think that's something you would have liked?
Yes and no. I guess it depends on from case to case, but in my case, we pretty much needed to hear every single thing because once we once, or in my head, whenever I was having a discussion myself, I was trying to play different parts of the same field, and I kept asking myself, well, why did this, and then like right after lunch, that question was answered, and then I kept asking myself what about this, and this, and then 10 minutes later, the attorney had addressed that, and I was like, okay, so I mean, you can, it's probably helpful, more or less, but it can also like not reach the finish point if you kind of jump the gun too much. Well, I mean, I'm just theorizing here, but yeah,
Absolutely.
it's best to hear out every single thing and try to get as much details and evidence as you can possibly get before actually getting the final word in. But I mean, if possibly having a quote unquote longer deliberation or more in depth deliberation, then yeah. But I mean, just having these little timeout breaks, deliberation throughout, it can. I don't know. Personally, it can be both good and bad. It just depends, I guess.
Interesting. Judges, what are your perspectives on this? Judge Hine, what do you think that this? I don't believe this is a practice done in Texas. I'm actually, if I remember correctly, it may not be permitted in Texas currently. Although, if I remember correctly, the Supreme Court had at one point recommended it as a potential innovation about a decade ago as well. But was that something you think you might use or recommend?
Well, you're talking about letting them look at the evidence before we finish the close of evidence?
Considered, maybe not